Welcome to my channel. I'm Cassandra Ramsey, the Esquire Coach, and today we're going to get into the landmark Supreme Court's decision in NCAA versus Alston. In 2018, former West Virginia football player Sean Alston sued the NCAA, claiming that their rules capping college athletes to a cost of attendance scholarship violated federal antitrust law. The NCAA defended by agreeing that their rules did in fact violate federal antitrust law, but claiming that their rules were necessary to preserve amateurism. Well, what is amateurism? Amateurism is the notion that college athletes only play their sport for the love of the game and that they are not paid. The NCAA claims that fans are only interested in their product because their product is distinct from professional sports. Well, what makes it distinct from professional sports? The fact that college athletes are not paid. Even though coaches make 6- and 7-figure salaries, the fact that college athletes aren't paid is what makes college sports distinct from professional sports. But I digress. In the case, the plaintiffs were able to show that the NCAA could preserve amateurism in a less restrictive manner. And that manner was for the NCAA to restrict to restrict non-education related benefits, but not restrict education related benefits. So the district court ruled and the Ninth Circuit Court of Appeals affirmed that the NCAA could no longer restrict education-related benefits, but could continue to restrict benefits unrelated to education. Even though the district court and the Ninth Circuit Court of Appeals affirmed the fact that the NCAA could determine what an education-related benefit is, the NCAA was still not satisfied with that decision and petitioned to the United States Supreme Court. And the Supreme Court heard the case and issued a ruling in favor of college athletes. This is a monumental moment for college athletes' rights, as this is a major step towards dismantling amateurism. This case does not completely dismantle amateurism, as the court, in their opinion, made it clear that this case only involves education-related benefits and does not address the broader compensation issues for college athletes, such as name, image, and likeness, and benefits that are unrelated to education. However, this case is still monumental for the college athletes' rights movement. In the case, or in the Supreme Court's opinion, they also made it clear that the NCAA's rules are subject to federal antitrust law. Therefore, the NCAA can no longer cling to that one line in the Board of Regents case, which was the previous college athletics case that the Supreme Court heard back in 1984. The NCAA can no longer cling to that one line that said that the NCAA had the job of preserving the rebel tradition of amateurism in college sports as their basis for supporting their asinine amateurism rules. And the court also made it clear to the NCAA that they will not be giving them an antitrust exemption, and that if they want an antitrust exemption, they need to ask Congress. This is a historic moment for college athletics and college athletes' rights. While this is a historic moment for college athletics, there is still one point that needs to be addressed. Even though the opinion was unanimous, Supreme Court Justice Kavanaugh wrote a concurrent opinion where he pointed out the blatant inequities in college athletics. He addressed the fact that college athletics is a billion-dollar industry propelled by student-athlete labor, and the athlete receives nothing but a scholarship. Many of those scholarships are not even full scholarships. Justice Kavanaugh also pointed out the fact that many of the players are African American and from low socioeconomic backgrounds. By Justice Kavanaugh doing this, he has made it plain for anyone to see that this issue is a civil rights issue. College athletes deserve to be able to receive more of the economic benefits that their labor bestows to so many others. If you enjoyed this video, please like and subscribe to my channel. Also, if you would like more information on college athletes' rights and name, image, and likeness, please follow me on the various social media platforms. Also, if you would like more information regarding name, image, and likeness, please download my free ebook entitled A College Athlete's Guide to Preparing for Name, Image, and Likeness. Thank you. See you next time.